Any mention for unlisted matter
Any mentioning? Yes.
from supplementary list? Item number 1.
This delay application, my lord. This case number 5. My lord, after the single bench
Any
judgment.
objection?
May it pleases your lordship. Lordship, there is a delay of 6 months, your lordship. 6 month delay is there, your lordship, as per the application.
Oh, you oppose it on merit.
Your lordship, let the matter be heard, your lordship.
Which matter? On merits.
For admission, your lordship. Yes.
On merits will hear. With regard to delay.
There is a delay, your lordship, 6 month delay, your lordship. Because
What is the reason given by you for the delay?
My lord, pursuant to the order being passed, my lord,
See, against which order you prefer this appeal?
both the orders, my lord.
Writ appeal?
The
Both orders.
both orders, my lord. The
So
review
how can a single writ appeal lie?
my lord, because both the orders stands merged, my lord. So
There is a judgment of Supreme Court. Against the final order, on the review order, you will have to file an
separate.
appeal.
Then, my lord, may permit me to withdraw this. I'll file a fresh, my lord.
But you argue it's not a problem at all, but you ascertain, I think.
Yes, yes, my lord.
We had an occasion to remember there are 2 appeals. Against the review, you have to file an appeal. Against the original order, also you have to file an appeal.
Your lordships are correct. It did occur to my mind.
Judgment of Supreme Court also.
My lord, kindly give me 2 days. I'll just ascertain and we'll come back, my lord, on this.
You ascertain.
Yes, my lord.
Tuesday, Wednesday?
Yes, my lord. Any day.
Wednesday.
Deeply.
Yeah, good reckoning, sir.
Any day. Withdraw.
What is his name? Law clerk. Arvind as a Bona or law clerk. And there is one judgment of recent judgment.
if it comes on 7, your lordship.
23, yes, 23 judgment.
Public.
Item number 2.
May it please your Lordship. Lordship, this is the issue regarding inundation of land in 2011, my lord. The Lordship had to show 2 pages, my lord, 316, my lord, agreement. 316, my lord. 316. Lordship is aware that here the land is owned by community, and this agreement is made on 5th day of May 2007 between Darbar Sanong, Rangbar Sanong, Hiriam CM Singh.
This is the matter which came last time.
Yeah, last week. Yes, Your Lordship. In that context only I am making this amendment.
It is so time to take instruction. Yes.
I am just addressing both issues.
Last time we said,
Yes, Your Lordship.
agreed to pay that 6 point and not.
Yes, Your Lordship. That is the point I am trying to converse.
You are not going to pay.
No, I want to pay, my lord, but kindly see 2 documents and then thereafter.
You pay that amount,
What is your lordship? The only issue is that this, if your lordship kindly see 2 pages and then the issue may get resolved, my lord. Kindly see page 154, my lord, page 154.
150?
Sorry, first page, your lordship, kindly see this document which I was placing before your lordship, my lord, 316, my lord, 316. Lordship, kindly see 316. This agreement on 5th May of 2007 is CM Singh represented by these 4 headmen, my lord. Then your lordship will link though, and then these are the 4 persons, my lord. And your lordship, kindly see the bottom of the page. Now, Srimati Surman Lingdor Nongri has agreed to donate land situated in so-and-so as per map annexed herewith and boundary indicated thereon in connection with the above-mentioned water supply scheme, free of cost, without any compensation and free of any charge of taxes whatsoever, and such land shall waste with the village Darbar free from all encumbrances. So the land was wasted in village Darbar entered into the contract, and pursuant to that, my lord, this project, if I can just place one more page, my lord, of this aspect, because here the claimant is not village Darbar. Compensation is not being sought by village Darbar. Now kindly see, my lord, the project, what was the project, my lord, and if your lordship will see 353.
353.
Yes, lordship. Where is that project document? Page 2. I'm sorry, my lord, the project document is 359. Because this project, my lord, was entered with the having this aspect in mind, my lord, that this is a water scheme which is centrally funded, my lord. Yes, sir, lordship. Kindly see 298. I'm sorry, my lord. Page 298 type copy is there. 298. And the paragraph middle of the page, my lord, paragraph 1. Meeting was chaired by Chief Secretary to so and so. Then small Roman 1, my lord. Tangai Combined Water Supply Scheme was accorded administrative approval under NRDWP for an amount of 10 crore 90 lakh, while administrative approval number 2007. The scheme is intended to cater drinking water supply of 21 villages habitation under Raid Nongri as well as village habitation under like Sirdarship at the source of water supply is River Unyu. Among other components, the scheme envisages construction of a small RCC weir across River Unyu at a location called Dikong under the Nongking village for creating necessary head to water flow, my lord. Now, my lord, the water from small RCC weir, small Roman 3, is to be drawn by gravitational flow to slow sand filtration plant, where after treated water is to be pumped to main reservoir located at so-and-so village. The scheme has been physically completed and commissioned during October 2015. Thereafter, villages were supplied with potable water regularly. Execution of scheme was carried out based on authorization of headman and darbar of the villages. Your lordship may kindly, the authorization of the headman and darbar of villages intended to be supplied with water. In March 2018, the administrative approval for payment of land compensation accorded to 5 crore rupees, right so and so by for balance. This is now 2 point, my lord. Deputy Commissioner is Khasi L. Ceylon, however, revised the value of land compensation to 78 crore rupees, so and so. Then 3, Chairman asked the Deputy Commissioner to verify how compensation amount so increased. Advocate General of the State opined that inundation of land was short period during 2011. No record to available that inundation occurred every year. Furthermore, cause of inundation could either be due to construction of dam or due to heavy rainfall. No notification for acquiring land was issued. If private land is inundated on regular basis for public, so then only acquisition to be initiated and compensation to be paid accordingly. My lord, this is the decision, my lord, and we have filed, my lord, because this is a project, central government project. We have spent 10 crore rupees. This was started on the premise that Darbar has given the land by gift, free of all cost, my lord. After 8 or 9 years, they say that no, you pay me the compensation because land was inundated once in 2011, my lord. And if your lordship will see, petitioners before your lordship are the persons who are not even signatory to the document, my lord. Now, because these are all centrally funded projects, my lord, we get funds from central government for various schemes. If we permit, my lord, this kind of re-looking into the entire project, we have got similar projects.
We are not going to do that.
Yes, sir, lordship.
After hearing the arguments,
Yes, sir, lordship.
I don't remember whether you were there on first day,
Yes,
or you
sir.
were on the screen.
Yes, sir, lordship.
But he said that we are not going to agree. If you want to accept, you accept the amount of 6 crores and not. offered by them, you take it and go.
Two issues, my lord, in this with regard to 6 crore rupees also, my lord. This is a central funded scheme, my lord. 10 crore rupees was the scheme. We spent 10 crore rupees. The water is being supplied. Land is not required to be acquired, my lord. In 2011, there was heavy rainfall, because of which adjoining land was inundated only once, my lord. It's like you are having land next to the pond. Because of sometimes heavy rain, it will get inundated. But that will not compel the government or state to acquire the land, because, my lord, I have to divert fund from other sectors because I don't have fund. This project is over. I can't go back to the central government. 2010, my lord, it is over. It was inundated once. Darbar has given the land. Darbar is not questioning the entire exercise. Now, few individuals have come.
The compensation will have to go to the genuine person.
Genuine person.
And they have identified. We ask somebody to identify the district council or somebody who is there to identify and pay the compensation.
When the only
Well, Advocate General, you must understand that we are not agreeing with them.
Yes, Lord. I understand. I bow down, your lordship.
Not agreeing with them. But the only thing is the offer you have made. It's a promise made by you.
No, I did not make any offer, my lord. There was no offer at any point of
You filed a counter.
No, counter, my lord, is with regard to that we were doing they raised the demand that our land is required to be undertaken. That is why in those
But
circumstances.
you agree to pay some rupees.
No, your lordship, there is no, I have placed that document, my lord. There is no agreement on our part to give any money to them unless, because our.
What is about the affidavit? Somebody has filed an affidavit.
Lord, there is some confusion in the affidavit.
Not there. It's on vote.
I understand. The affidavit is also, if you lord, you will see the affidavit is so vaguely worded, because sometimes it happens, my lord, my difficulty as a statement.
They are also poor people. Now we are not saying that you get the money from the central government. Since you have acquired and you are doing it, give it to the welfare of the people.
We have not as such acquired, my lord. Only 1 year the land was inundated. That is 1 year, my lord. And my difficulty as a state is that if we have to go back, because similar agreements have been entered by various darbars throughout across state.
Proposal to acquire a land will not give them a right.
Yes, Lord.
Unless there is a notification acquiring the land, right? They are arising therefrom only they will be entitled to compensation.
Yes, Lord.
Here you have agreed everything.
The lordship, I quite see what is falling from your lordship. Your lordship, Darbar is a necessary
Are you
party.
going to pay or not? That's all. The simple direct question we are asking.
I have placed the difficulty of the state before your lordship because Darbar is not questioning me. Land belongs to Darbar, my lord. We have filed impediment application. Let Darbar be here, my lord. So the situation will be clear. Who are these persons? Where their lands are being required? There is no clarity, my lord. Only one survey has been carried out. Even they have not annexed title documents showing that they are having land whose land are getting inundated every year and because of dam. That is why, my lord, in last affidavit we sent that.
We are not saying that the entire amount should be paid to one person.
Yes, lord.
Let the person in charge identify to whom the money should go, how much they are going to get. Let the money, if there are any balance amount, let it go to the government. Let the balance amount go to the government.
I quite see, my lord, let the Darbar, I have moved the application for implement of Darbar. Let Darbar come before your lordship. And then if we have to pay, we'll pay that.
What is there? Let them come.
My lord.
Any of you- See, this court is inclined to give you some relief. Let them come. Tomorrow let them not come and say that I have not been heard. I don't have no knowledge.
My lord,
What is it?
my lord, I deeply
Let them come.
appreciate, my lord, the conciliations, my lord, compromise is one
So
of
you
the
must
key.
understand that you are on a weak wicket.
My lord, I will not take lordship time. I'll just take one order passed by this Supreme Court after they show this agreement, and I'll place 3 judgments regarding the impeding
We are
applications.
willing to hear the matter. We want to give a quietus to the matter by
My lord.
ensuring that you get some money.
My lord, that is why, my lord,
Further, let them be there.
my lord,
Please ascertain.
therefore, I also take instruction from the party.
Sir?
If the government is going to pay the 6 crore along with the interest, they are agreed. They are peace loving people. They are not that they are coming here to claim their land which they don't entitle. But they are agreeable. Therefore, let the age is sort
What if we will persuade the 4 persons who are going to be implemented?
And my lord, the 4 persons who are seeking for implement, they are not the signatories.
At that time, we'll say that you are not a signatory, we'll sideline them.
My lord, therefore,
We'll bring them, then we can sideline them. It's not a problem.
I'll just point out one order passed by this very bench regarding this issue, particularly this issue. Lordship, in my show goes, Lordship, page 140.
Sir?
140 in my show cause reply. The order passed by this court.
If you want to argue the matter.
My lord.
That's all. Ultimately, if you're going to lose a case, then they can't help it also.
But I just want, my lord, lordship permission, I want to show.
I don't think I'm willing to argue on merit, my lord.
You're going to argue the matter.
But I am ready, my lord. I'm ready with regard to miscase. Since they moved the miscase, my lord, I want.
You must understand the court's mind. The court is inclined to give you some relief. Which you're not interested, then we can't do anything.
My lord, it is not that I'm not interested. I come here, my lord, with powering down, my lord, seeking relief from my lords. My lord.
Let them be impleted.
They want to impede a stranger.
We will say that they impleted merely because they have impleted, they have got every right.
My lord,
Land is donated by Darbar, my lord, and my friend is having objection to the treatment of Darbar.
I don't interfere.
Sir?
When learned AG argue, I don't interfere. I request not to interfere. My lord, inundation started in 2011. They never say that, no, land is donated by you, so we don't need to conduct survey in your own. They never say. First, in 2016, we filed the detailed affidavit that yes, you are the landowner. 2019, the second petition we filed, they filed a second affidavit, they said, yes, you are the landowner. But the only problem is that we are not taking over your land is not under the water. I said you have taken over my land, the land is under water. These are only disputed. The land division bench and single bench say there is element of dispute question of facts. That is the one. Now, pursuant to single bench direction, they conducted the survey. And the survey report clearly says that the submersion as stood on in 2011 still continued till today. And whose land? It is my land, in their own affidavit. No affidavit, they admitted. They never said it belongs to the third party. Therefore, I'll just mention
That is what we have stated from the bench. Let the land be identified, and if you are entitled person, see, you may be entitled to, X may be entitled to, Y may not be entitled to. Let them be identified, let the compensation be given on out of the 6.6 crores or whatever it is. If the remaining amount, the balance is available, let it go to the government.
But I just would lordship profound respect, man. I just beg lordship attention to page number 140. 140.
146.
140 of mine.
140.
140 of mine. Show cause, filed by the appellant. Number 1. The same argument advanced earlier before this very bench, and this observation was made by this Honorable Court. Page 140. My lord, with the permission, 2 reports have been filed by the state pursuant to the previous direction. Reveals the physical survey of the entirety of the land. At paragraph 4 of the report, it is indicated that the total area of land which is submerged as a result of the dam being constructed is such and such square meter. The state seeks to suggest that the entirety of such land is covered by an agreement of 2007, by which the Khairem Sameachip donated the land for the purpose of dam upon obtaining the same from Srimati Sumaman Lington Nongri. However, the agreement May 5, 2007 does not indicate the extent of land. Instead, the agreement refers to a map appended thereto to cover the extent of land donated thereby. Physical survey that has been conducted refers to 24 plots in all, about 11 of them belonging to Sumaman Nongri. However, the map at the last page of the survey report indicates areas which do not appear to be covered by the area indicated in the map appended to the agreement of May 5, 2005. Indeed, in the survey map, the land of Sumaman Nongri has been indicated beyond the 24 plots which has been surveyed and which said to be submerged as a result of the construction of the dam. A second report has been filed and rendering drawn photographs of the area. If there is any further dispute, since the photograph has been taken during peak monsoon season, such a photograph along with the survey map would indicate the extent of the land which has been submerged upon the construction of the dam. What is written is that the petitioners other than Sumaman Nongri may not have donated any land for the purpose of the construction of the dam. Well, it is permitted possession on the basis of the survey report.
Sir, by reading this order,
Yes, sir.
7 and 8,
Yes, sir.
it's very clear
Yes, Lord.
that by construction of the dam, certain persons have lost the land.
Your Lordship, that is the dispute, and that is why the learned single judge directed district judge to hold the inquiry, my lord.
But anyhow, this order is passed by the division bench
Yes, Your Lordship.
against the order of the learned single judge.
Yes, Your Lordship.
It's an interim order.
Yes, sir.
Passed on 16th August 2023.
Much water has flown after this, my lord, because they were insisting on compensation. So, and the project, in fact, Your Lordship, kindly see my last affidavit. Pursuant to the order passed by this Honorable Court, my Lord, we filed the affidavit saying that if the cost goes beyond, because we have to do the cost benefit analysis, and if the cost is so much that this project is not viable, we will dismantle the dam, because a small dam is there, we can have it some other place, and that figure even under Jal Jeevan Mission, my Lord, if we have to use one, because as per Jal Jeevan Mission, 1 lakh rupees is to be spent for one household, my Lord. So if we have taken into account the entire scheme, still in that scheme, my Lord, it will be not viable project, my Lord. So we have decided, in fact, we have given affidavit before Your Lordship that we will dismantle the project, so that if there is any issue of inundation, land will be with them if they are Darbar. And the only issue what I am saying, my Lord, is that so far as whether this Mr. Surman has given the land or not, or Darbar has right or not, all these are factual question of dispute, my Lord. And as on today, they have not. This is a survey conducted by
According to you, this court cannot decide about the compensation.
Your Lordship, that because we have to issue advertisement. If I have to issue advertisement, invite all bodies, all those objections will come, my Lord. Who is entitled to and who is not entitled to. My friend is also objecting to implement of Darbar. Darbar is local guardian and Darbar is having land, my Lord. All these issues are there, and therefore we decided not to. In fact, we have implemented the project. We spent 10 crore rupees on their promise. Now they say that no, our some land is getting inundated. We have today also, Your Lordship, I called the chief engineer. He said that the land is absolutely dry. There is nothing. Only during the monsoon season some inundation takes place, my Lord. Now then the question is of the benefit of the larger public interest, vis-a-vis inundation during some period of time, if I admit that, my Lord. So, and the project is of 10 crore rupees, my Lord. That money we have got, somehow we have spent it, developed the project also, my Lord.
Project is completed.
Project is completed in 2010. They raised the objection in 2018, my Lord. We came for the first time in 2018, and Mr. Suraman is saying that I am having 11 plots, my Lord. He did not raise objection at any point of time. Surman is, kindly see my 318, my Lord, 318 of the page, my Lord. Surman is one of the signatory to the agreement, 318. Kindly see, his name is 316.
Of your paper book.
316, yes, my Lord, paper book, 316, my Lord. See, sorry. See, my Lord.
Here is the diagram.
In 316, my Lord, if Your Lordship will see the paper book.
316.
Yes, Your Lordship. And the agreement deed, and the bottom of the left side, Your Lordship will find signature of Srimati Surman Nongri, landowner. And before that, there
Where is it, sir?
316, my Lord.
316.
Of the writ appeal paper book, my Lord.
Oh.
And Your Lordship will see left side, my Lord, signature of Surman Nongri, landowner, and just opposite that line only, my Lord, kindly see, Srimati Surman Nongri has agreed
It
to.
also say the persons have got to be identified. Even this person may also get compensation. That's what
And Your Lordship, kindly see this line. Srimati Surman Nongri has agreed to donate land situated and so as per map connects here with boundary indicated in the above mentioned water supply scheme, free of cost, without any compensation, or free of any charge of taxes, whatsoever, and such land shall be in village Darbar free of all encumbrances. I am asking village Darbar to be party here, my Lord. If the land is donated to village Darbar has it.
they have agreed to pay, agreed to give the land. Not given the land.
And they have given the land, and this agreement is of 2007, my Lord. They have given the land, therefore we started the project.
Where is the proof that they have given the land?
Because my Lord, we have started before 2018, they have not even raised any murmur. When the project was complete in 2015, they said, we want compensation, my Lord. Now they are making U-turn, my Lord, because this is a dishonest, otherwise we would not have.
They are making U-turns.
Because in 2007, my Lord, they gave the land and said that the land can be utilized for water project, my Lord. We constructed and completed the project in 2015, my Lord.
We are not saying that the dam that has been constructed should be demolished.
Yes, Lord.
We are not on that.
Yes, Lord.
It is for the public purpose.
Yes, Lord.
Which you have taken it and you have done it.
Yes, Lord. On the promise.
Some of the persons whose name has been identified in page number 17 or 18 in your typeset of paper.
This is a general survey which was carried out, my Lord. Nobody has placed the title document.
No, the estimate of probable acquiring the land. You've given the names of persons.
No, my lord, this is a survey conducted by district survey officer.
Pursuant to the orders of the court.
No, it was conducted on our own before that, my lord. So
Same direction.
this was survey was conducted, my lord. As on today, they have not even filed the title document. There is no title document showing that they are honest, my lord.
Advocate General, we are saying that we'll identify the amount.
Yes,
together
sir.
with the interest.
Yes.
Those person interested is entitled to approach the appropriate authority,
Yes, Lord.
showing the document, title to the document that they are the owners of the, then they will get the compensation.
Yes, Lord.
Proportionately from the return amount, anything lying is so that
I understand. 6 crore rupees, I have no problem, my lord. Whatever is falling from your lordship, I'll follow, my lord. What at this point of time is, my lord, the land was donated to Darbar. Your lordship has seen the agreement. Darbar will come because Darbar is ultimately custodian of land, my lord. The donation has taken place. Darbar and my friend is opposing the implement of Darbar. I don't know why, because Darbar here, my lord, land is basically community owned. There are two types of land here, re-kinti and re-right. Re-kinti is the individual land, re-right is a land owned by community. So therefore, I was praying that if the land compensation has to go, Darbar and
sir, we let the impleading be ordered.
yes.
Let the impleading be ordered. Let the final objection be.
My lord, with due respect, my lord, I'll just
I find the
I'll
implement
just
of
place three citations. What is the lordship report my submissions? Allow me to place a few decisions regarding this case implement. They are filing this application after 7 years of litigations. And the law is very clear.
Going by your argument, we have to say that you approached this court after 8 years. So on the ground of latches, the writ petition has got to be dismissed.
No, madam. We
Then what will apply?
Lordship,
If Darbar is here, what is the difficulty?
1 minute, let him finish. We heard you. Take rest for some time.
Yes, madam. We never interrupt when he argues.
Huh?
We never interrupt when Leonard H. argues. But unfortunately, when he argued, he jumped upon, well, I request him not to do that. Well, look, regarding this application, well, I would never resist the application if they file the application in time. Now, after 7 years of litigation, we filed this application. Regarding this, I'll place only 3 Supreme Court judgment, my lord, and I raise my submission.
For the impleading petition.
Regarding impleading application.
Yes.
Not on the merits, since the lordship is hearing for the impleading application. My lord, first I will come to the judgment, my lord, 2002, volume 2 SC, page number
2002,
volume 2 SC, page number 210.
200
210.
210. Yes.
210. Now the writ petition was filed in the Supreme Court directly, and at the last stage of the proceeding, they filed impleading application in what the Supreme Court held. Page lordship may kindly, relevant para would be, lordship may kindly come to running page 210, and lordship may come to 216. 216.
Yes.
My lord. It is Constitution of India, Article 32, parties are standing. Application for impleadment as a party intervener, belated application, such application filed at the stage of final hearing rejected, may come to relevant para 37. Running page 231. My lord, 37. Incidentally, in this writ petition, there is an application for impleadment by reason of failure to pay on the part of the company and its director. We do not see any reason, however, to implead the applicant herein at this stage of the proceeding. As such, we pass no order on the impleading application. The last stage of the hearing matter, application was moved. Supreme Court said it is belated, rejected. Another judgment may I place, with lordship permission, is, my lord, 2012 volume 8. 2012 volume 8. SSC page number 384. Under the broad principle for impleadment of a part, the Supreme Court emphasized. The broad principle.
2000?
2012, volume 8 ACC, page number 384.
Yes.
And relevant para would be, my lord, para 41. Para 41, my running page would be 413.
41.
Para 41. Para 41. May remain, with lordship permission. Though there is apparent conflict in the observation made in some of the aforementioned judgments, the broad principles which should govern disposal of an application for implement are: the court can at any stage of the proceedings, either on an application made by the parties or otherwise, direct implement of any person as party who ought to have been joined as plaintiff or defendant, or whose presence before the court is necessary for effective and complete adjudication of the issues involved in the suit. A necessary party is a person who ought to be joined as a party to suit and in whose absence an effective decree cannot be passed by the court. A proper party is a party whose presence would enable the court to completely, effectively, and properly adjudicate upon all matters and issues, though he may not be a person in favor of or against whom a decree is to be made. If a person is not found to be a proper or necessary party, the court does not have jurisdiction to order his implement against the wishes of the plaintiff. In a suit for a specific performance, the court can order implement of a purchaser whose conduct is above board and who files the application for being joined as party within reasonable time of his acquiring knowledge about the pending litigation. However, if the applicant is guilty of a contumacious conduct or is beneficiary of a clandestine transaction or a transaction made by the owner of the suit property in violation of the restraint order passed by the court, or the application is unduly delayed, then the court will be fully justified in declining the prayer for imprisonment. Unduly delayed, 7 years of litigations. First round, single bench, division bench, they never take this plea, non-joined our parties. Even secondary petition also, they never take this plea. Single bench pass a final order. They comply with the direction of survey report placed before lordship's considerations. Lordship pass an order.
The earlier bench in 16th August 2023 have passed an order
Yes.
referring to this donation.
Yes.
Correct?
Yes.
When there is a donation, unless that party concerned was not going to be heard, what is the relief that can be granted to you? And it amounts to dispute request of fact. In order to give a quietus of the matter, we want them to be here. Tomorrow they need not say that no, the land belongs to the community, not belong to the individual. Suppose we pass an order, it binds them. It binds them. That is the reason why we are saying.
Well, I bow down, my lord, regard that point, my lord. But see the application filed by the party after 7 years. The last citation of lordship permission, may I cite, my lord? 2008, volume 5.
2000?
2008, volume 5. Volume 5, page number 117.
See, all these, you are quoting one judgment on a criminal matter, two are from CPC. Do you mean to say that the powers of this court will be curtailed?
My lord, my lord, the CPC Order 1 rule is very much aware. Order 1 rule 13 very clear. Regarding objection for non-joint parties should be taken by the party at the earliest opportunity. That is the principle of lordship. Is
Can
very
the
much.
powers of this court be curtailed?
Lordship,
Simply.
lordship, enough power.
Well, see,
my lord.
it is only the procedure, civil procedure code.
Madam.
So, this is not bad. In fact, in a contempt matter, one of the arguments taken by the parties before the Supreme Court was, under section 20 of the Contempt Codes Act, the limitation is only for a period of 1 year. Beyond that, you cannot take. The Supreme Court has held that under Article 215 of the Constitution of India, the powers are wider, and by means of section 20, the powers of the court cannot be curtailed.
Madam, there is no dispute, madam, regarding that.
So you are
Is
quoting
absolutely
this
correct.
judgment, a provision with regard to CPC, and say that High Court has no powers.
Madam,
Also, when there is a justice has got to be done.
madam, Now, the only, Lordship, can bear with me, the order passed by this very bench on August is, my lord, out of 9 writ petitioners, one appears to have donated her land. Remaining writ petition number 2 to 9, remaining, they don't donate. Now, they also, they do not donate the land. And it is not the case of the state respondent.
So there is no donation at all.
There is no donation at all. Therefore, the Learned Division bench of this honored court made it very clear that if
we will record it, let them be here, come.
My lord, therefore, Lordship kindly
We'll pause or come.
record my, and only the last submission is, my lord, if Lordship impledes, my lord, they may come and say, my lord, whether the writ appellant number 1 has donated the land or not. They can come and say, the newly impleted party may come and say whether the writ appellant number 1 has donated the land or not. They may come and say. But they have no right to say whether the other remaining appellants.
If they say that we are here to question them, how can you say that you are prevented from doing it?
At this stage, my lord, there is no evidence to show that the other landowner has donated the land.
Sir, in this state, the land belongs to the individual or to the community.
My lord.
Not to the state.
Lordship is correct.
Correct?
Correct. Lordship is correct.
So after coming here, I have learned this.
Lordship.
So, now the issue is, in this case, whether the land belongs to individual or the community. The land, some of the land may belong to the individual, some of the land may belong to the community. It is better that the person who has signed the agreement is heard and decision is rendered, and no prejudice is going to be caused to you if they are heard, and a composite order can be passed in the writ appeal.
My lord, may I just point out the signatories, my lord. May I just point out who are the signatories and Lordship be passed on order. Signatories, Lordship kindly see page number 317.
What?
The signatories in the agreement, page 317 of the memo of appeal.
Your affidavit.
In my lord,
300?
317 of the memo of appeal. The signatories.
This particular 4 people on it. This one is
The agreement deed.
My lord. Four headmen has signed.
So you are referring to the agreement deed.
Agreement did, my lord.
Yes.
Agreement did.
4 persons have done.
Four persons, my lord. Now, Lordship, may kindly see page 360. Their names are clearly mentioned. My lord, 4 headmen are mentioned. Lordship got it. 316, page 316.
16, yes, sir.
My lord. The serial number 1 and 4 are no more. They are still alive.
Still alive.
Still alive. So they are the right person to say whether it is donated or not. Number 2 and 3 are no more.
No more.
No more. They died away. And second,
They are sought to be implemented as a party.
Implement of the villages, my lord.
The first one.
Your lordship, can you see my implement application?
my lord, all the present headmen,
See, they are implemented as a
Headman.
representative capacity. They are a headman, not with individual capacity.
my lord, Lordship aim is to ensure that whether the land is donated or not.
Sir?
Now, the Lordship aim is to ensure that implement them so that the implemented party will come and clarify. That is a attempt to be made by Lordship. Now, the present existing 4 headmen, they are not at all the signatories. So if the signatories are alive, my lord, Lordship endeavor will be more fruitful if you Lordship implement this headmen who are alive. Who are
First one.
First and fourth.
First and fourth.
My lord, they are the right persons. They come and clarify.
What is 2 and 3?
Otherwise, you are
Lordship,
outside.
yes, if your lordship kindly see the agreement and my miscellaneous application, both side by side, my lord, the headman is an elected post by the district council, my lord. Now, headman is a post which is held by individual time to time, my lord. As on today, this post is being held. So the government come and government go, my lord. It is the headmen which are being sought to be implemented, my lord. So my friend is having objection because headman is the custodian of land. Headman is the final authority. And what is the difficulty if these headmen are there, my lord?
They are not the headmen, in fact. They are the locality head only. Village headman is there.
We can say that they are implemented as a headman and only under headman capacity they are entitled to file an objection.
Yes.
What is going to happen? Nothing is going to happen. Individual capacity. See, a person can be made as an individual capacity if there are any bias or any allegations are made. Unless they are made in that situation, then you cannot seek any relief. Now, the relief is only against the headman. Headman is going to come and say whether there is an agreement or not. Whether as per the agreement, lands have been donated or not. No prejudice. Come.
And if I so my friend has
Page number 378.
317.
378, the map. Lordship has just now pointed out clearly. 378, the map. Lordship see the map? Well, 318. The map.
It is a diagram.
The diagram. This is the map. My lord, the landowner mentioned this entire map.
Here are all these things when after the party comes on record. We are not going to render any finding in your favor or in his favor. No.
My lord,
We are going to say that they have to be heard. So, what is the implementing application, sir?
Your Lordship, the implement application number is miscellaneous W writ appeal 2 up to 2024, my lord.
Of 2024.
And in fact, my friend has shown one order of your Lordship. I wish to show the division bench order, my lord, of 4th October 2023. Your Lordship, kindly see the 4th October 2023 order of division bench, my lord.
Come. The present application has been filed. Implead so as party respondents. The contention of the Advocate General is that the land in question has already been donated and that if the area in question has been acquired for the purpose of, has been taken for the purpose of constructing a dam which has been fulfilled. Now the water supply has been given to 21 villages and that after a delay of 8 years, the writ petition has been filed seeking compensation which the writ petitioners are not entitled to. Full stop. He would further submit that he has obtained, the government, the central government has funded money for the purpose of construction of dam and the state government jointly with the central government fund has constructed and completed the dam. Since the headman who has donated the land and that the land belongs to the community, they are to be heard in this writ appeal. Full stop. The counsel appearing to the respondent in the application vehemently contended that the entire land belongs to the individuals and that the government has initially decided to acquire the land, but for the best reasons known to them, they have not done so, and that the land has got submerged in the floods and that they are entitled to the compensation. Full stop. You would further submit that initially approximately a sum of rupees 7 crores was offered for the purpose of as compensation payable to the parties concerned, which was ultimately not done, and that they are entitled to much more compensation than the one offered by the government. Full stop. We are not inclined to go into the merits of the contention raised by the parties here. Full stop. The only point to be decided in this application is to whether there shall be an impleadment of the parties concerned. Whether the land belongs to the community or not, or to the individual, the headmen shown in the impleading petition are impleaded in the representative capacity of an headman and not in individual capacity. Also, though it has been stated that there is a donation of land, this court has got to ascertain about the extension of compensation, at least as offered by the government, as contended by the respondent herein. Full stop. Though this court has suggested as to whether the government could extend the compensation of rupees so and so together with interest in order to give a quietus to the matter, the Advocate General submitted that after hearing the headman about the donation of land, and in case of individuals available, the same has got to be identified, and thereafter only the compensation need to be paid. It does not mean that the government has agreed that the exorbitant compensation as demanded by the writ petitioner to be given. Full stop. Taking note of the submission, that we are of the view that the persons who are sought to be impleaded is a necessary and proper parties to this this writ appeal. Full stop. The council has relied upon, the council for the respondent has relied upon the decision 123 set. Full stop. First case will be pertaining to criminal matters, the other two with regard to CPC. The powers of the court cannot be curtailed by the procedure laid down therein, as it is the case of the petitioner that they are entitled to compensation and their livelihood is lost on account of loss or non-payment of compensation by the government. Impleading order, notice to the impleaded respondents returnable by 20th of March. The parties are directed to serve copies of the papers on the impleaded respondents in order to enable them to file their objections.
Obliged.
Item number 3.
Reluctance. So this is
Yes. You ready? Both of you are ready?
My lord.
Yes. Then we'll take it up as the last case.
Last case, my
We'll
lord.
finish the list and take up.
My lord.
On the daily list, item number 1.
Please, Your Lordship, in this matter, Mr. BK Sharma is leading counsel in this matter, my lord. Due to some personal difficulties, unable to appear to Your Lordship today. He's requested me to take time on his behalf, my lord, and seek for a date on 5th of March, my lord, if that is convenient to Your Lordship.
5th of March.
5th of March, my lord.
The request of the council appealing with the appellant. Who's the man? How many cases are there on 5th?
Justice Jindo, 9 cases. 9 cases.
9 cases.
Justice,
5th, I
thank
think
you.
2 final hearing cases are there. Any other day?
Thank you.
Ascertain the convenience of the senior advocate and give the date.
My lord, I'll do
And
that.
inform the convenience of the advocate general also.
Lordship. Obliged.
Item number 2.
My lord, this is a public interest litigation, my lord. Herein, my lord, the petitioner has raised the issue of alarming number of accidents and casualties caused by
Here in
the,
Shillong.
yes, my lord, caused by the two-wheelers. My lord, state has filed an affidavit.
Only possibility after reading the papers, I find that only bicycles alone can be allowed. All roads are very small.
My lord, this widening of road also is
What do you mean you have to take the land, acquire the land?
right. My lord, in fact, the affidavit which has been filed by the state, they have conducted some inspection and made some recommendation, my lord. These are at page number. If my lord will come to page number 7 of their affidavit.
7 of the affidavit.
Affidavit filed by the state. First.
1 minute, sir, 1 minute. Page number
7, my lord.
7 of your affidavit
Affidavit filed by the state, my lord, yes.
by the state.
Yes.
Police, Superno Police, the Prasad.
Yes, my lord, right. Paragraph 17, my lord.
Paragraph?
Paragraph 17, page number 7.
Yes, sir.
Here, my lord, the last paragraph I will just point it out, my lord. Here it says, furthermore, numerous joint inspections have been conducted along with officials from the office of the
One
DT.
minute, 1 minute, sir, please.
My lord.
Yes.
Yes. My lord, the third paragraph I am reading, sub-paragraph, that furthermore, numerous joint inspections have been conducted along with officials from the office of the DTO, PWD.
Paragraph 9,
Paragraph 17, my lord.
7.
Page number 7.
Page number 7,
Paragraph 17.
7E.
This affidavit is dated 12th of February, my lord.
12th February, 1 minute. Yes, sir.
My lord, the third paragraph, sub-paragraph, my lord, paragraph 17, page number 7.
17.
Paragraph 17. That furthermore, numerous joint inspections have been conducted along with officials from the office of the DTO, PWD, NHAI, and NHIDCL throughout East Khasi Hills district pertaining to road safety. During the inspection, various issues relating to the road accidents and traffic congestions along with probable solutions have been identified with suggestion to the concerned department for necessary actions from their end. Solutions suggested include the following: widening of narrow intersections, improvement of bottleneck within the city limit, filling up of potholes, barricading of footpath, erection of road signals, proper road marking which includes zebra crossing, embankment and disembarkment points, central marking, parking bays, etc., installation of convex mirror at blind roads intersections, speed limit signboards, delineators, cat's eyes, etc., constructions of pedestrian infrastructure. Now again at paragraph 20, my lord, page number 9, it says measures. Following are the steps, measures proposed to be undertaken by the state respondent. Intensifications of vigorous checking, especially for reckless and negligent riding of two-wheelers and underage riding round the clock at every strategic location of the district. Awareness of program covering more schools and localities for students and general public. Community traffic management involving local headmen to disseminate information on traffic announcements through PA system in every locality. Strict enforcement of Motor Vehicle Act, joint checking in collaboration with other line department. Numerous locations have been identified for installation of ANPR, automatic number plate recognition cameras under the Smart City project for detection of traffic sources offences. Steps will be initiated with all concerned departments in order to conduct joint inspections of earmarked speed limit throughout the city, district, and erection of speed limit signboard thereupon. Installation of automatic speed.
Anyhow, these are all the things they have said that they are going to do it.
Right, my lord. So now, my lord, what we need is we need implementation of all these measures by the state. Unless these measures are kept in place, my lord, the incidents will keep occurring. My lord.
May it please your lordship. Lordship, so
Why
far,
don't you have cameras so that link to the traffic, wherever there's a illegal traffic or wherever the person can be immediately caught and fine can be imposed?
in fact, your lordship, this step as stated in this affidavit had been done so far. Regular checking on the road, setting up of NACA checking, your lordship. All this had been done, your lordship. Then in some part of the area also, your lordship, a speed breaker had been constructed. All this had been done, your lordship. It's not that we are remedying. We have not done
So
anything.
these steps have already been taken.
My lord,
Lordship, some of the step, your lordship. Some of the step.
What are the steps? Well, then when are you going to do it?
Lordship, it may
So
not.
this is your affidavit that these are the things you are going to do it. When are you going to do it? See, one other thing is, though it has been stated that automatic number plate recognition, etc., unless you have
This will take some time, your lordship. It will
you
take
need,
some time.
the
your lordship.
cameras
right.
linked to the police department.
This will take some time, your lordship. It will take some time.
How long?
Lordship, it may be 2 months, 3 months, your lordship. Because this will have to.
So with regard to para number, in order to implement para number 20, it will take 2 months time,
Let it be 3 months, your lordship.
3 months.
3 months.
My lord, time may be given, my lord.
Have you deployed sufficient police for the purpose of regulating the traffic to avoid overtaking, etc.?
Lordship, yes, they are on the road, your lordship. Traffic police are there on the road. They are doing their job.
You must have deployed, whether they are there or not.
They are there, your lordship. They are
Not in
there.
all places, my lord. There are
They are there,
many
your
places
lordship. They
where
are there, your lordship.
deployment of police is required.
They are there, your lordship. And those people without, especially those two-wheeler, if they don't have a.
See, what is not available here is that the link to the police department, the police, the traffic police, with the camera.
Cameras.
Install cameras in say various places.
This will take some time, your lordship.
That
because
is a
this-
very effective measures, my lord.
Here in para number 20, you have stated numerous locations have been identified for the installation of so-and-so cameras under smart city protection for detection of traffic offences.
And my lord, in one of the point, my lord, which I would like to raise, there are places where they have put the no entry signboard, whereas there is no police personnel deployed there. What happens, my lord? Sometimes there is traffic violation, the people enter through the no entry, whereas the other person which comes from the other side, he is not aware. He is going without any fear that other person will come from the other side. Accidents takes place, my lord. At least in no entry, wherever there is no entry, there should be a deployment of one police person.
Maybe those are a stray incident, your lordship. Otherwise, your lordship, the police, they are on the road, your lordship. They are doing their job very fine, your lordship.
So ensure the first step, what you have to do is to employ police officials in all the places where there is going to be a traffic jam
Lordship.
initially. Then ensure that there is a camera.
Lordship, all this, because this will come under the smart city project, Your Lordship. It may take time, Your Lordship. It may
Yes, it
take
take
time.
time.
It may
Take
take
time.
time, Your Lordship.
It's a small place, then we can easily do it. Is it not?
Lordship, yes.
If you take Singapore, it is a maximum will be 25 kilometers by 25 kilometers. They've done it. Here is a maximum of Shillong will be around 8 kilometers. Would not.
Maybe more than that, Your Lordship.
More than that.
More than that. Plus the suburb and all, Your Lordship.
No, I'm saying about the city.
A city, it will be around 10
8 to 10 kilometers.
Lordship, yes.
Because here the schools are there. The children are.
Especially during the school hours, after school hour, Your Lordship, we have massive traffic jam that we cannot deny the fact, Your Lordship, because the roads also are very narrow, Your Lordship. There is no scope also for further widening of because of the building and all houses of.
The matter is taken up for hearing. The matter is taken up for hearing. The council appearing for the state would submit the steps are being taken to curb the menace pointed out by the writ petitioner, and the affidavit dated 12th February 2024 has been filed with regard to steps or measures proposed to be undertaken by the state. It has been contended by the writ petitioner that there are no police personnel available even at the entrance where there is one-way traffic, and that accident takes place on account of wrong entry by the violator. The council appearing with the respondent would submit that there may be stay incident, but strict enforcement as per the Motor Vehicles Act will be taken, and that they require 3 months' time to implement the proposals so that the menace pointed out by the writ petitioner is curbed at the earliest point of time. In order to enable the respondent to take effective steps and file the status report, the next date of hearing, before the next date of hearing, call the matter on 3 months around date. Maybe around 29th, almost March, April, May. On 3rd June.
Lodge.
3rd June.
Lordship, in this matter, we also file a second affidavit, Your Lordship, because there was a subsequent order passed by this honorable court, Your Lordship, that we filed yesterday, Your Lordship.
By?
We filed yesterday, Your Lordship, the affidavit.
Affidavit.
Yes.
But you filed it on 12th February. That's what we have recorded it.
Yes, Your Lordship. Then there was an order, Your Lordship, that we should take step. If Your Lordship kindly have the second affidavit filed.
February.
Lordship, if Lordship kindly come to page 11, Annex 1 of that affidavit, that is the order passed by this honorable court. Lordship, I'll take Lordship straight away to page 12.
Page?
Page 12 of that affidavit.
12.
Lordship, yes.
There are 12 or page 12?
Page 12, Your Lordship. That is the order
only 10
passed by
pages
this.
available.
Lordship.
Affidavit is 10 pages.
Lordship, no, that is the Annex 1, Your Lordship. That is the order.
Annex 1 is 11, yes.
7/2/2024.
Yes, sir.
Lordship, kindly come to page 12. These are the observations, Your Lordship. And Lordship, from Annex from page 13 onwards, Your Lordship, these are the steps we have taken, Your Lordship. These are the steps we have taken, Your Lordship, in compliance with this order.
It further stated that the
Lordship.
pursuant to orders of this court, dated so and so, an affidavit dated 28th February 2024, pursuant to orders dated 7/2/2024,
Lordship.
the affidavit dated 28 February 2024 has also been filed, enclosing the annexure,
The action taken, Your Lordship.
taking the steps taken
Lordship.
with regard to parking of vehicles and other remedies for that poses a serious hazard to the flow of traffic and the life of the pedestrians. Etc. According to him, the state is very keen to ensure that every citizen of the state is a law-abiding citizen, and that they will ensure that the proposal suggested in the earlier affidavit dated 12th February, no, not 12th February, yes.
13, Your Lordship. That is 13/2/2024.
Sir, the earlier is dated
13, Your Lordship. 1/3. We file on 13, Your Lordship.
12th February 2024 is complied with. 12th February you are given in para 20
Oh, Lordship.
that you will comply with this in its entirety
Lordship, yes.
in 3 months' time.
Lordship, some relaxation may be given, Your Lordship, because like installing this camera, because it falls under the
So
smart.
we have given you
It
3
may
months'
take
time. You take steps. What are the effective
Lordship,
measures
yes,
you
we'll,
have-
we will inform Your Lordship accordingly, Your Lordship,
Yes.
on the next date fix.
Yes.
Apply.
Apply, Your Lordship.
Item number 3.
Lordship, Lordship, may I seek your Lordship permission? May
Yes,
I seek
sir.
your Lordship permission, Lordship? Before the start of the proceeding, Lordship.
Yes, sir.
Lordship, in fact, in this matter of item number 3 and 4, a transfer petition has been moved before the Honorable Supreme Court by the state of Manipur, and it will be coming up very soon, Lordship. So I think I seek some accommodation for that, Lordship, because the main petition, a main writ appeal 20 was already transferred back to the High Court of Manipur, as the quorum is available, and in terms of the direction passed by the Honorable Supreme Court in the last order, Lordship, of 19 January.
Now,
19
pursuant to
January.
the order of the Supreme Court only, the matter has been transferred to Manipur here. No,
Yes, there are
you want the matter to go back to Manipur?
Yes, Lordship, two matters was transferred, writ appeal 20 and 21, which was numbered before the Honorable Meghalaya High Court. And Lordship, the main writ appeal is writ number 20, and that writ number 20 has been transferred back to the Manipur High Court now by the Honorable Supreme Court by the order dated 19 January 2024. Thereafter, on 30 January, by this Honorable Court, the said writ petition has been directed to be transferred back to High Court of Manipur, and now it is back in the High Court of Manipur, Lordship. So the item number 3 is actually a consequential order to the order which is been challenged in writ appeal 20, which is the main case, which has been transferred back to High Court of Manipur. And item number 4 arises out of writ appeal 20, the main case which has been transferred.
Also to go back.
Yes, Lordship, because it has to be heard together, Lordship. So when it was mentioned before the Honorable Supreme Court asked for moving a transfer petition in one of the SLP which was filed thereafter, Lordship. And now the transfer petition has been filed and a diary number has been generated also, Lordship.
Can you forward the diary number?
That is 9384, Lordship.
What, 9?
9384, Lordship.
9384 of?
2024, Lordship.
When is it filed?
Lordship, 27 February, Lordship.
21st?
27, Lordship.
27th of February?
Yes, Lordship.
My Lord, may I submit, my Lord? My Lord, in any case, item number 4 cannot be transferred because that is the contempt petition out of the order that is passed by this Honorable Court here at Meghalaya, my Lord. In any case, that could not be transferred back to Imphal because this Honorable Court is to decide whether.
See, the way the connected matter is there, but
my Lord, the contempt is of this Honorable Court's order, my Lord.
it's the order of the court.
My Lord.
So ultimately, Supreme Court will have to decide whether it can be transferred or not. They filed a petition.
Yes, sir.
My lord, last time, my lord, when this case was taken up, they took up 1 month's time and they filed yesterday, my lord. That's what they are saying. My lord, right from the beginning, my lord, they have been using one tactics or others, my lord. What happened, my lord? They even brought the learned single judge judgment was stayed by a division bench, and thus so to see that, and it was stayed by the division bench, and then they brought in an advocate related to the one of the honorable judges who recused. Therefore, we did not have any bench at him file. So we moved the Supreme Court, and Supreme Court transferred it to here in this High Court, my lord. Thereafter, they filed application for adjournment one after another on one ground or other. This Honorable Court even observed in one of its order that we make it, we put it on record that the time lost will be restored once it is found that the judgment is wrong, my lord.
So we will wait for 2 weeks' time.
2 weeks, my lord.
When the matter is taken up for hearing, item 20 and 21, it is represented by the council.
I am the State Council, Special State Council.
State Council. Council appealing to the state.
Special State Council.
That writ appeal 20 of 23 has already been transferred to Manipur, and that when the connected or main matter is transferred, this matter has also got to be transferred and heard by the Manipur bench. You would further submit an application for transfer. Why diary number so and so has already been filed on 27th of February 2024 and is likely to be heard. The council appearing for the petitioner would submit that the order of this court has been violated and that the respondent are facing contempt and that this court alone is empowered to take up the matter. Since a transfer petition is already pending before this court, we will await for the orders of the court. The matter is adjourned sine die, and depending upon the outcome of the orders in the miscellaneous petition, the parties are entitled to mention the matter before this court to take up the matter and pass appropriate orders. You mention the matter after disposal, then we'll take up the matter.
Obliged, sir. Deeply obliged. Obliged.
Item number 5.
Must oblige.
My lord, this matter, yesterday my colleague has received the affidavit filed by the other side. We are yet to go through, and lordship may give me 2 weeks' time to obtain the instruction from the party and liberty given to us to file a short rejoinder. Yesterday they have filed.
What is the matter about?
This matter relates to the validity of the appointment and succession of the Maharam Act 2019. We are questioning the validity of the
enactment.
Enactment.
They are saying, Your Lordship, that the Annexure 12, which is at page...
So file your objections.
I have already filed my affidavit.
Yesterday, yes.
Saying that this matter was placed in the House and passed.
Yes.
Otherwise, it has become...
Appellant. Who's the matter?
Writ petition.
Writ petition.
Is a writ petition.
Sorry, the request for the writ petitioner. Who's the matter? When do you want?
After 2 weeks, sir.
Who's the matter after 2 weeks? Ascertain the date, and depending on the number of matters, give the date.
I know.
Item number 6.
Yeah. But the registry there to list the matter before the bench consisting of Chief Justice and Justice. Thank you. Yes.
My lord, I am for the appellant, my lord. My lord, this is the case, my lord, where we are challenging an order dated 15/9/2023. Lord, before that, my lord, I would like to just give a brief description about the case, my lord. Now, my lord, the petitioner, my lord, herein, the appellant herein, he was working as a technical assistant since the year 2013, my lord, Negrims in the anatomy department.
What is the issue involved in this case?
Yes, my lord, what has happened? He was terminated from the service.
Terminated.
Prior to that, my lord, I need to give a brief description about the case, my lord. He was working in the said post as a technical assistant, my lord, since the year 2013. And thereafter, my lord, what has happened is the administrative officer, General Administration Negrims, issued an order dated 2nd July 2019. By that order, it was stated that informed that the employees who were earlier appointed on contract basis in the institute shall be engaged through outsourcing under the terms and contract of present contract. What has happened is, my lord, they were on contractual basis, and thereafter they have issued this order saying that all people who are engaged through contract basis, they will be henceforth appointed through outsourcing. Now this is a post of technical assistant. And therefore, my lord, the petitioner came before this Honorable High Court by way of WPC 253 of 2019, saying that such post of technical assistant cannot be appointed through outsourcing, and I have relied on a judgment of the Honorable Andhra Pradesh High Court, where it said, my lord,
Is it a permanent sanctioned post?
he was
The
on
post in which you are working
Yes,
is
my lord.
a permanent sanctioned post.
probably so, my lord, because this can be answered by the council.
You are working, is it not?
Yes. No, my lord, if my lord will come to page number 37 of the writ appeal, page number 37 of the writ appeal, my lord.
Page 37.
Yes. Here, my lord, at paragraph 4, I have relied on a judgment of the Honorable Andhra Pradesh High Court, where it stated, and just highlighted portions, my lord, since there is no challenge in the present batch of writ petitions to the said government order and present issue related to the engagement of service of certain persons through outsourcing method in the medical and health department, this court purposely refrained from expressing its view on the validity of the above state government order, but confines its examinations of entrusting the duties of nursing and technical staff in the government hospital through outsourcing method. Now it is well established that the right of life and personal liberty enshrined in Article 21 includes the right to health. In Vincent Panikulangara versus Union of India, the Honorable Supreme Court referred to Article 47 in Part 4 of the Constitution, which reads as follows: duties of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties.
So
And
you are reading the judgment, sir. What is your case?
yes, now, my lord, as per this judgment, my lord, it says such appointment cannot be made through outsourcing method, because in cases of outsourcing, my lord, the person who is doing the recruitment process, he is totally incompetent. He is not from the medical field. And therefore, my lord, we challenge by WPC 253 of 2019. And my lord, that writ petition was disposed of void dated 15/7/2019, my lord. By permitting the appellant, my lord, will come to my synopsis only, page number B.
Yes.
That writ petition was disposed of void dated 15/7/2019 by permitting the appellant to file a 15/7/2019. By permitting the appellant to file a comprehensive representation by incorporating the claim as has been raised in the writ petitions within 15 days from the date of receipt of copy of the order.
To consider and pass orders.
Right.
Yes.
But what has happened is, my lord, they did not consider and they have terminated my service, my lord.
Terminate your service.
Yes.
Yes.
They terminated my service, and therefore, my lord, I filed a second writ petition, my lord, challenging my termination order. That is WPC 424. The order of which I am challenging. That is page number 24, my lord. 24 of my writ appeal, page number 24. That is the press writ petitions I have filed challenging my termination order. The court has directed the respondent to consider my representation. What they have done is, my lord, while order dated 3rd September 2019, they have released me from service. That order is at page number, my lord.
Where is your representation? Where is the earlier order?
Earlier order is, my lord.
Where your request has got to be considered and appropriate orders to be passed with the authorities. Where is the order?
Yes, my lord. This order is at page number 58, my lord. 58.
58.
Yes, my lord. Operating part is page number 59.
Oh, yes.
Operating part is at page number 59, my lord, paragraph 5. After hearing the learned counsel for the parties and perusing the writ petitions without expressing any opinion of the merit of the controversy, the writ petition is disposed of at this stage by permitting the petitioner to file a comprehensive representation by incorporating the claim as has been raised in the writ petitions within 15 days from the date of receipt of the copy of this order before the respondent number 3. It is directed that in case such representation is filed before the respondent number 3, the same shall
What is
be...
your representation?
My representation is the next page, that is page number 60, my lord.
Yes.
And page number 70 is the termination order.
This is your representation.
Yes, my lord. 60 to 69. And page number 70 is my...
60 to 69 is representation and they have the term.
70 is termination order.
Yes, sir.
My lord,
Your document considers representation pursuant to the earlier orders of this court.
my lord, we've considered, my lord. My lord, I'll just state the brief, the background, my lord. My lord, there are two posts of technical assistant in anatomy department, my lord.
Technical assistant.
My lord. Two sanction posts, my lord.
Two posts.
My lord. So one post was filled up in 2016 itself, my lord, by a regular appointee.
2019.
16, my lord.
16, yes.
My lord, one post remained, my lord. So there he was appointed on contract basis. Now what happened, my lord? There was, lordships are aware, there was a policy of deemed abolition of post, my lord.
Deemed abolition.
My lord, by the central government.
By the central government.
My lord, we said that if any post is not filled up for 2 years, my lord, then those posts will be deemed to be abolished.
Who is at fault not filling up the post?
No, my lord, I'll just now what happened, my lord? And a decision came from the government of India that henceforth there will be no contractual appointment, and all appointments will be through outsourcing, my lord, through third party outsourcing agency, my lord.
No contractual appointment.
No contractual appointment. All appointments to be through outsourcing, my lord.
Outsourcing.
my lord.
This is a sanctioned post.
My lord.
This post is sanctioned.
Sanctioned. It was sanctioned, but it has been deemed abolished, my lord.
How do you say it's a deemed abolition?
Deemed abolished, my lord, because
By which rule?
that has not been annexed, my lord. But in my affidavit, if I may take your lordship to
No,
that.
not the hire and fire policy.
But it was not exactly a hire and fire policy, my lord. My lord, what happened? The policy of the central government was that, my lord, if any post is not filled up, that means that the department
There is no
cannot.
requirement for the post at all.
There is no requirement, so it will be deemed.
That the regular post
My lord.
has been made as a contractual post.
My lord.
And thereafter the outsourcing, which means the job is a perennial nature and the work is required.
So, my lord, accordingly, because that very policy says, my lord, all posts will be deemed abolished. If any department feels that any post is required, they have to write to the central government for revival of the post, my lord.
Here, my lord, as per my instruction,
1 minute, sir.
my lord.
Let him complete. They will,
So, my lord, the institute has written to the government for revival of this particular post, my lord, but till now it has been not been revived. So, once we have given an undertaking before the Honorable Court, once the post is revived, my lord, we will re-advertise the post and then he can apply to the post, my lord. But,
then he'll be overaged and he'll attend age of graduation.
my lord, that was his prayer before the learned single judge. That can be considered, my lord, at that point of time when the advertisement is issued, my lord. If his age can be condoned in the
Advertisement, then how will they do it? If the advertisement is not going to say that the age relaxation should be given, then it will be problem. How can you abolish a post? Under what authority you have done it? Abolition? Do you have a LLJ here? Labor Law Journal here? You have Labor Law Journal to take 1985, Volume 2, LLJ, page 4, Food Corporation of India. The other one is 1990, Volume 1 or Volume 2, LLJ. I think 444 or 446, I don't remember the judgment. Pick those two judgments. The LLJ is available, get that. 2 volumes, 3 volumes. Yes.
My lord, our case was, my lord, that the appointment given to him was purely contractual, my lord. If I may point out the order of appointment, my lord.
How long you have been appearing? How many you have been working?
But he worked from 2013 till he was released, my lord, on
2019.
19, my lord. 6 years,
2019.
my lord.
Initial
6 years.
appointment was only for 6 months. They extended from time to time.
13 to 16, you have been working. When was the post abolished? SEC la check பண்ண சொல்லுங்க. Check the SEC. 1985. Do you have anybody who is having the SEC online, the phone? Try that Uttarakhand of India case, 1985.
My lord, page 55 of the paper book, my lord.
55.
But decision was taken that all contractual will be converted into outsourced, my lord.
But the director was also informed that the employees who were earlier appointed on contract basis shall be engaged only outsourcing. So they are changing from page 55 contract to outsourcing.
My lord.
But in 2013 he was directly appointed, not on contractual basis.
He was on contractual basis, my lord. His appointment, my lord, I'll just point out, my lord. Page 50, my lord, page 50.
50.
Yes, my lord. On contract basis for a period of 6 months, my lord.
Where the order of the learned single judge?
At page 96, my lord.
96. Come. 1985, volume 2, SEC 136. Yes.
Well, page 96, my lord. My lord, learned single judge has held, my lord.
Where is a judge in para 3, so and so, appearing for the response submitted the post held by a petitioner should abolish with the office memorandum dated 12/6/2017.
My lord.
Where is it? In page number 97, it is referred. Kept all the posts indicated were kept in abeyance and remaining vacant for 2 years in ministry of so and so. Shall be deemed abolished. Where? Yes. He has been directly paid the amount. When was this? 2017. 17.
My lord.
But on the date of this memorandum, he was in service.
He was on contractual service, my lord.
Huh?
My lord, the post against which he was served, he was appointed on.
He was a contract labor,
My lord.
and his job was entrusted through outsourcing,
My lord.
and thereafter he has been sent out.
Because what happens, my lord, once we appoint through outsourcing, my lord, the selection is done by the
Who was
outsourcing.
paying the money? Who was paying the salary to him
Earlier, my lord,
earlier?
by the institute, my lord.
By the institution.
My lord.
So there was a direct payment.
There was a direct payment, but he was not appointed following.
Exactly. The Supreme Court says once on introduction of system of direct payment by the employer, thereby abolishing contract labor system, the workman acquired the status of direct workman of the employer, held unilateral discontinuation of direct payment system without workman's consent, and reintroduction of contract labor system, treating the workman as a contract labor would amount to termination of service in the absence of compliance with the law. In this case, you have gone the next stage. You have not brought him back as a contract labor.
Yes.
You have made him as a
Outsourcing.
then terminate. That's bad. That's what Supreme Court says as early as in 1985. Give him employment without back wages. It's a permanent sanctioned post.
But the post doesn't exist as of now, my lord. That is the difficulty, my lord.
Post doesn't exist.
My lord, person is working in outsourcing method, my lord. In the
You are
same,
not working.
my lord, even now working, my lord, appointed through outsourcing.
Appointed through outsourcing.
Outsourcing.
Now that means you require a hand.
Yes.
We require the hand, my lord. The difficulty is that particular post doesn't exist, my lord, as such.
In which case, if he is taken as the entire period will be taken as continuous service for the purpose of granting terminal benefits. You continue him, don't disengage him in outsourcing. In the post is revived, you absorb him directly. That's all we can do. The Supreme Court is against you. There are two other judgments, we are trying to get that.
Well,
You don't got LNG? Don't got LNG. One of the judgment of Punjab Haryana, the other one is I think Nagpur judgment, Bombay Nagpur judgment.
my lord, the direction is issued that he'll continue in outsourcing, my lord,
Yes.
as an outsourced employee, my lord. But he'll not be replaced. He'll be there, my lord.
That is that he will be there.
My
But as and when the advertisement is issued,
My lord.
the post is revived, he must be put back in service and the entire period. What?
My lord, the difficulty
When
will,
him as a contract employee and as a it should be taken counted for the purpose of terminal benefits.
my lord, terminal benefits will not come into picture, my lord, because
If any, if applicable. How do you say not entitled to any terminal benefit? Gratuity is there.
my lord, gratuity and other things will be there, my lord. My lord, only one aspect, my lord.
Gratuity is there.
My lord, only one aspect.
Contributory pension will be there.
My lord, because once a post is revived, my lord, by the government, we have to advertise the post, my lord. So only if your lordship directs that he'll be eligible to apply against that post, his age can be
Suppose he is
condoned.
not eligible.
Otherwise, he
Having
will be.
extracted. Sir, it's not correct, sir. Not correct.
Because without advertisement directly absorbing him, my lord,
What to do?
at the most, your lordship directs that his age will be condoned and his candidature will be accepted and he'll be assessed in terms of the
Certain
advertisement.
things we can't set it not. Probably would have seen it in newspaper in Tamil Nadu.
My lord.
A district judge who has not studied law became a district judge and retired. So we can't ask him to go and study law. See, in this case, the office on the day of office memorandum, he was in service. Outsourcing person. You have?
On contract basis, my lord.
Huh? Which one? What this? Not 19. I'm asking you, Punjab Haryana High Court judgment and Nagpur, Bombay bench. It's reported only in LRG. See, the case, Bombay High Court and the Bombay Court, Nagpur bench and Punjab Haryana, in an Industrial Dispute Act, they came to a conclusion that when work itself ceases to exist, then there can be a question of termination, retrenchment, all those things apply. And if you are going to continue the employment under the guise of contract, the provision of 22 will not be applicable. The same principle applies. You are allowing him, you make a direct payment for a contract labor, then make him as an outsourcing agent, then terminate him from service, and again allow him to work through the outsourcing person, which is not correct.
Because, my lord, the difficulty will be, my lord, if Lordship kindly sees the outsourcing order, my lord, at page 56, my lord, page 55 onwards.
50?
55, 55. Page 56 is a list, my lord. Page
That's right.
There are as many as 49 employees, contractual employees, my lord, were converted into outsourced employees, my lord.
Now he has come before this court. We don't know whether others are working or not. Suppose they are not working, they may not be entitled to. Suppose you dispute the case, then the remedy may not be in the High Court also. Now these are all admitted facts. He'll proceed on the basis of admitted fact. We'll let him continue as an outsourcing person.
My lord.
As and when the post is revived,
My lord.
you give him all the benefit of a regular employee from 2013. In the sense, the entire period will be taken into account for the purpose of terminal benefits, if any applicable. Definitely gratuity is eligible. Gratuity is eligible.
But the difficulty, my lord, if a post is revived, my lord, we have to advertise that post, my lord.
You advertise the post less one. Less one. See, the problem is, the Supreme Court has clearly said in 2006, in Uma Devi's case, backdoor entry is not permissible. And you are allowing everybody to work. Then whenever comes, at least not here, I think from tomorrow you may quote, in Madras, this happens. The government takes the employees, allow them to work. When they seek for regularization, they quote Uma Devi case. Yes. They would have been recruited in 2010, 11, 12, 10 or 15 years, they would have worked. See, one of the orders, we have quoted Uma Devi's case in the Supreme Court and held that it was there. Knowing very well about the judgment, you ought not to have employed that. Allowing them to continue, government has given a go back to Uma Devi's case. Then you cannot take shelter under Uma Devi's case. Para 43 and 53 of the judgment is very clear in the Uma Devi's case.
Because his initial appointment in 2013, my lord, was not following the due recruitment process, my lord. He was just simply.
It was through advertisement.
There's nothing on record.
Advertisement is there, my lord, and closed.
Where is the advertisement?
Page number 48, my lord.
40?
48.
48.
Yes, there was advertisement.
After advertisement, my lord, he have been appointed.
See, you advertise for direct recruitment. After advertising for direct recruitment, you engage him. After selection, you engage him on contract basis. That's very bad. Listen. Okay. See, it is nothing but a hire and fire policy. You must statement understand that the employees are not commodities. Because understand. And whatever you give, they will sign it. That's what in 1986, the Supreme Court says the relationship between the employer and employee is like the lion and the lamb. You are the lion, he is the lamb.
Vacancy.
Come. See, now that the notification is there, that you are not challenged. Notification with regard to abolition of the post. So they are waiting for that to be restored.
Issued by Ministry of Finance, my lord.
Yes. So you will be entitled to employment.
My lord.
You continue to as such draw wages as and when there is an advertisement
My lord.
for the post. In one post you will be eligible without any selection process because you already got selected and appointed.
My lord.
Strictly speaking, on the face of this advertisement, the notification itself is bad. And the gap of 2 years will not be applicable to the present case. Because he was in service when the notification was issued in 2019 or 17, whatever the date.
17. He was in service since
2000?
He was in service since 2013 and notification came 2017.
The circular.
Circular 2017, my lord.
17. He was in service on that date.
My lord.
Not only one aspect, my lord. My lord, Lordship kindly looks at the advertisement, my lord.
Not this statement. This is not verbal. Yes. Correct. One other judgment. Correct. Not for judgment is also there.
Contract basis.
Walk-in interview is to retain होगा regular post के लिए.
So the Bombay High Court says, NACO bench, a stipulation in the contract that the employment would be for a specific period or till the completion of work may also fall within the scope of the clause. But if the employer resorts to contractual employment as a device to simply take out of the principal clause, irrespective of the fact that the work continues or the nature of duties which the workman was performing or still in existence, such contractual engagement will have to be tested on the angle of fairness, propriety and bona fides. Maybe such fixed tenure of employment are made to frustrate the claim of the workman to become regular or get himself confirmed as a permanent employee, either under the rules applicable to the employment or even under standing orders. It is always open to the court adjudicating the dispute to examine each and every case in its proper perspective and protect the workman against the abuse of amended provision. If such protection is not afforded, the benefit flowing from so and so to which every termination succumbs would render nugatory. This is what they say in Bombay. And Punjab Haryana still says the hire and fire policy is bad.
Or only one aspect, my lord. In the advertisement, I will also kindly sees, my lord. Page 48.
so as to limit cases where the work itself has been accomplished and the agreement of hiring for a specific period was genuine. If the work continues, a non-renewal clause of contract on the face has to be dubbed as malified. It would be a fraud in law if it is interpreted otherwise. That's what the Punjab Haryana says.
But only one point.
You don't have a case.
But only page 48 I wanted to just point out, my lord.
Page 48.
My lord, there is an advertisement, my lord. My lord will see at serial number 1, my lord. My lord, for example, serial number 2, technical assistance for an anatomy department, so and so, 5 years experience, consolidated amount rupees 11,360 plus 50% DA. He was not on a regular pay scale, my lord, only on a lump sum pay scale, my lord.
Sir, how will he know? That's what we say. The contract is between line on the lamp.
Not only
how
that.
Will they know?
Not
See,
only,
that about you have stated that it is only for a period of 5 years. The experience, with
experience,
the 5 years experience, yes.
And my lord, on the next page, my lord, job mode, my lord, contract basis.
Which one, sir?
Page 49, my lord. Interview venue, job mode. Is
Right.
On the next page, my lord, you will also see serial number 6, data processing on the top, my lord. Thereafter, applicant's age limitation, selection process, date and time of interview, interview venue, and thereafter, my lord, job mode. Contract basis, my lord. So it was purely contractual appointment, my lord.
Whether the contract is sham or not, we will decide. That's all. It's a ruse or camouflage. You want to use a word.
But in my humble submission, it's not that, my lord, because even recently we issued advertisement for other posts, my lord. Because as and when posts are sanctioned, my lord, because recruitment process to carry out also is a massive exercise, my lord. You have to hold examination, conduct interviews, and there are all India applicants, my lord. So
the employee or the person who is going to come for the selection process have no role over the advertisement.
My lord.
And they are governed by the advertisement.
My lord.
Clauses and conditions stipulated therein.
My lord.
But if the clause contained is not bona fide, when a person approaches the court is empowered to say that such clause is bad, is arbitrary, smacks victimization. We can say that.
My lord, but if that is held, my lord, all contractual appointments will go, my lord.
No, not all contractual employment. If there is genuine contract, for example, you will be having contract for the purpose of laying road. After laying road, you'll have to go. You can't say, give me break some other road and give me work. You can't say that.
Well,
that is different. Where here the assistant work is required.
my lord, what was the idea, my lord?
See, when out of 2 persons you have selected, 1 person is working, another person is on contract.
My lord.
Which means what is it? And you are still employing him.
No, my lord.
Can you? We'll pass orders.
They have terminated my service.
That is all. To test it or give him employment.
My lord, we will order directs to continue as, on outsourcing basis, my lord. To that extent, we have no problem. Lord, will kindly consider that aspect.
We'll dictate the order in detail.
My lord.
Obliging.
Because your lordship interface with the deemed abolition notification, my lord, that will have all India ramification, and many things have happened pursuant to that advice.
No, we are not going to say. We say that only 1 person has approached. If other person approaches this court, you can still take a plea of delay. Latches is there. Supreme Court said one person gets a relief, all should be granted relief. No doubt about it. But if they must also be here, they can't say they will sleep over the matter and wake up from the slumber and knock at the doors of the court saying that so X has got, so I must also get it.
Because my lord, the 2017 office memorandum applies all across the country, my lord. So if any interference with that will have very far-reaching consequences.
We'll see.
My lord, kindly, my lord, to that. As far as giving appointment to this person is, your lordship, kindly confined to that only, my lord.
Yes, we'll see, we'll think about it.
But
Second call,
Deeply.
supplementary list, item number 3.
Yes. Send the judgments also. There are it's SEC also, it's Xerox it and give it. Take a printout, not the book.
deeply.
This last case, pass on. Where's your friend?
He was here, my lord.
He was here, your lordship.
Yes.
Lordship, last occasion has already heard this matter, my lord, but I'm just to refresh my lordship's memory.
Payment of gratuity.
Lordship.
Yes.
Lordship, the appellants are before this honorable court, my lord, challenging the interim judgment and order dated 21st/9/2023, my lord.
Where is the order?
Page 203, my lord.
20?
203, my lord.
203.
Lordship. The relevant portion will be from para 8, my lord.
Para?
Para 8,
8.
page 207, my lord.
Oh, that government scheme.
Lordship.
Yes, yes.
Now the single judge has held, my lord, that I'm not a regular employee.
Which result of the termination of employees and labor. Yes, sir.
Lordship, the single bench has held, my lord, that the appellants are not the regular employees, my lord. The Payment of Gratuity Act, my lord, the word employees does not talk about a regular employee, my lord.
You are covered by the scheme. You are covered by the scheme.
Lordship,
Where is the scheme?
scheme,
You have been appointed based on the scheme, is it not?
Lordship.
Where is the scheme?
Scheme, my lord, is
Not based on the scheme, sorry. The terminal benefits have been granted based on the scheme.
they made a one golden handshake scheme, my lord.
One-time settlement, golden handshake.
Golden handshake scheme, my lord.
Yes. Where is the scheme?
Lordship, we have not been enclosed here, my lord. It is not there, my lord.
We know that how can we come to the conclusion whether you are entitled to or not? Where is the scheme, sir?
My lord, scheme as such, they have never enclosed, but I would like to say something, my lord, before we go into any of the other inquiries that falls from my lord. Now, what they're trying to do is, they're trying to unsettle something which has been settled since the year 1996, and then 2001, and then 2006. Why I said 1996, the first is because these appellants, the appellants were hired on the basis of an agro-custom hiring. Now, what was that agro-custom hiring was, my lord? It is for some kind of development of agricultural and horticulture in the border areas, my lord. That was a scheme of the government, not my scheme. And I am a PSU, my lord, public sector undertaking, and our organization, federation, is known as a MECOFED, my lord. And we are a registered society, my lord, under the registration of
Society Registration
Act, my lord.
Yes.
Now, my lord, we were given as an implementing agency. So now what happened was that, so if we are given an implementing agency, we were required to hire
some employees in order to ensure that the scheme of the government comes to functions. But subsequently, what happened was that the function, the aims and objective of the scheme did not work out. So 1996, the government decided to stop the scheme. Now when the government decided to stop the scheme, what happens to the employee? We can't absorb them.
Correct. They'll have to be sent out.
Yes.
Following the due process of law.
Exactly, my lord.
Correct.
So what happened was that then the government, then there was some options came out by some modalities were worked out. How do we retrench these employees who were hired under the scheme? Then the government came out with a settlement saying that we will give them one-time amount and let them go. So we have.
Where is the scheme, sir? Based on which scheme they have settled their accounts?
My lord, unfortunately, that scheme, my lord, because it is not in our office also, my lord, that scheme, that agro-custom scheme, because that's a government scheme we were just given under this. So therefore, I am in the handicap, my lord, to show the scheme to my lords.
Definitely a scheme must be available. How do you say the scheme is not available?
My lord, and in my office, my lord, I'll have to take instruction, but to the best of my knowledge, my lord, that scheme, and this is a 1996, very old scheme, my lord.
See, although the government records, will
Yes.
definitely be updated and will be in the website.
My lord.
Government a party here?
Yes, double AG is representing the government, lord.
113.
See, these employees,
Yes.
sir, these employees who have been hired through a particular scheme
Lordship, correct.
has been disengaged on account of non-fulfilling of employment on account of various factors. They have agreed to receive the one-time settlement by accepting VRS. This is what I think last time we
Lordship.
were able to recollect.
Lordship.
VRS. Only issue is they have not been paid gratuity.
Lordship.
That's the only issue.
Yes.
For can you by means of a scheme deprive the employees gratuity in terms of payment of gratuity act?
Lordship will kindly appreciate, Lordship, that
This is what we said. We asked somebody also to read section 14. I think some lady lawyer appeared.
Yes, my
Last time.
friend's junior, I think.
Her colleague, your colleague, your colleague.
Somebody appeared. I think she also appeared. I think junior on record, she also appeared
The
that day.
counsel, his assistant counsel of the MECOFET was, Lordship has directed her to.
We refer to section 14 also.
My lord.
The counsel represented the MECOFET matter on that day.
If you see section 14,
My lord.
contracting out is not possible, not permissible.
Section 14.
In regard to scheme, my lord, I've got
Even by entering into see, it is an industry. Even going by a settlement under section 18(1) of the ID Act,
Yes.
or by means of a 12(3) settlement,
Yes.
you cannot take away the rights
Yes.
guaranteed under section 14.
Yes.
But we're not guaranteed, protected under section 14.
My lord, I fully agree to the statutory rights, my lord, that by any, but now, my lord, what we are saying is, my lord, now the other question comes, if that is the arguments that
What is the amount you're asking?
Lordship.
How many of you are there? How much money you are asking?
Now, my lord, only two of the appellants have approached before this honorable.
How much you are asking?
The last time payment was 80,000 something, my lord, which was given by them.
Huh?
80,000 something was given by them, my lord, as a one-time.
80,000.
80,000 as a one-time payment, yes.
What was your last down wages?
Last was 2,000 rupees.
How many years of service you have rendered?
21 years, my lord.
Huh?
21 years.
2,000
I've
rupees.
also, my lord, I've already filed that.
No, just we want to know. We'll see the
21 years, 11 months.
2,000 rupees you have rendered, 21 years of service.
21 is 11 months, my lord.
21 years, 11 months.
Lordship.
So 22 years of service you have rendered.
Lordship.
Yes. 2,000 divided by 2,000 multiplied by 22 divided by 15.
Lordship.
It's 15 days, a 1 day salary. the years of service. 2,000 divided by 15 is 1 day's salary. Into 26 into 22. So you calculate, what you have to calculate is 2,000 divided by 26 into 15 into 22. This is a calculation. 2,000 rupees divided by 26 days, which will come for 1 day, multiplied by 15 is equal to 15 days salary into years of service. How much it comes?
24,230.
24,000.
24,000. I mean, subject to correction, my lord.
Whatever it is.
Subject to correction.
Most probably all of us must be very weak. That is why we have taken law. Yes. Yes. How much it comes?
25,384, man.
25,000?
384.
384. 84. Whatever it is. Nearly about 26,000 rupees. 26,000 rupees per person. You have accepted the compensation.
Lordship.
2 persons. Why don't you give 50,000 each and give a quietus to the matter?
My lord, first of all, my lord, this will open a floodgate, my lord. The floodgate. This will open a floodgate, my lord. And why I say so, I fully aware when I say this, my lord, financial crunch is not my excuse, my lord. But I would say that whether they have the vested right, now, my lord, seeing this, my lord, after 21 years, my lord, after 21 years, they're coming before this honorable court.
In my humble submission, my lord, they have extended the benefits.
My lord, understand?
Yes.
Suppose they have gone before the gratuity authority.
My lord.
Gratuity authority would have condoned the delay.
My
because
lord.
it is a beneficial legislation.
Exactly, my lord.
So, how many employees are there? Apart from these two?
Apart from these two, my lord.
Other employees, my lord, but they are not before this honorable court, my lord. There were other employees, my lord.
My lord, under one condition, under one directions, if clearly my lord gives one observations, my lord, we can consider their patient that this should not be taken as a precedence, my lord.
But we'll see that we'll also state that the delay they cannot knock at the doors of this court.
Yes,
and
my
we
lord.
can say that this cannot be treated as a precedent.
Precedence, my lord. My lord. That we can consider, my lord. Otherwise, why, my lord, what?
Because others cannot wait.
Yes, my lord.
For one person to get an order and thereafter approach this court.
My lord. My lord. Because, my lord, particularly...
Suppose you will be paying, what is the salary? All are getting 2,000, these 2 persons.
Only these 2 persons, ma'am.
2,000 per month.
Watch it. Because last paid one was only 2,000, my lord.
It will become to less than 1 lakh.
My lord. Why we are, my lord, we saying, because, see, my lord,
we... Unlike other enactment, Gratuity Act...
Yes, my lord.
Protects the employer's right under Section 8.
Exactly, my lord.
If you see Section 8, last proviso, last subsection...
Yes, madam.
It says interest cannot be more than the principal amount.
Yes.
So 26 plus 26 will be only 52.
We can consider, my lord, but only thing is that, my lord, as I just to reiterate myself, my lord, that this should not.
When did you oppose this court?
2022, my lord.
2022. 22. When was the disagreement? Divesting of duties.
2001.
2001. So you come after 21 years.
Exactly, my lord.
So you accept the principal amount of 26,000. No interest.
Yes, ma'am.
No interest.
Lordship, because they extended the benefits towards those persons who approached the honorable court only in the year 2021 also, my lord. And they extended the benefit of leave encashment as well.
It is different. Now you are concerned about gratuity.
Gratuity and leave encashment both, my lord.
Huh?
Leave encashment both, my lord.
Leave encashment, how will you know that you have got so many days leave to your credit? How can we adjudicate? Sir, you are converting this court into an adjudicating court, labor court.
Yes.
How can you adjudicate?
No, humble submission, my lord.
Where is the proof that you have got leave to your credit?
Lordship.
Where is the evidence to that effect?
There's no evidence, my lord.
Then, how can you do it? You cannot expect the court to conduct a rolling inquiry.
Lordship. My humble submission, my lord. In the year 2021 also, my lord, there were other employees, similar situated employees who approached this court.
Sir, you must understand, if we grant relief to you, though we may say that it cannot be treated as a precedent, some person may come and knock at the door of the court.
Yes.
The court may say, treat this also as a separate case, give them benefit. Why should you open a Pandora box?
Yes.
Lordship.
You accept 26,000 rupees and give a settlement, give a issue to this. What does it matter? We are not going to grant interest because of the delay of 21 years. The Payment of Gratuity Act
Lordship.
state that you are entitled to interest. Still we are entitled to reduce it on account of laches. Though we, if you see the judgment of Supreme Court in 1981,
Yes, ma'am.
Lordship.
81 102 LLJ page 1, it says the gratuity is not a gratis or bounty.
Lordship.
That's what the Supreme Court says.
Subsequently followed by Allahabad. There's a case from Allahabad also, my lord. It is.
So you will be entitled to gratuity, but for the delay you are not entitled to interest.
Lordship, I'm just relying on
justified in
relying on judgment, my lord, in regard to scheme, my lord. In regard to scheme, here also.
you have not produced the calculation, you have not produced the scheme,
Lordship.
and you are arguing, the learned judge was right in rejecting on humanitarian ground that the fact that you have employed, which has not been disputed the number of years,
Lordship.
we are asking them to pay this 26,000 rupees. Beyond that, we will not do.
My lord.
Lordship. I'll leave it to your discussion, my lord.
That's all.
My lord. Obliged.
But 16 persons have approached this court, only 2.
Only 2, my lord, has approached this honorable court, my lord. 16th were there and single bench, my lord. Common judgment was passed, my lord.
The present appeal has been preferred against the order of the learned single judge in WP number so and so dated so and so, whereby the plea of the writ petitioner for grant of gratuity has been rejected. Gratuity and other benefits have been rejected. Full stop. Though the counsel appearing for the writ petitioner was an appellant that the employees have been deprived of gratuity for the services rendered and also leave encashment. Come on, there is no evidence to the effect about the leave encashment, the entitlement of leave encashment. Full stop. The writ petitioner appellant cannot convert this court into a roving, this court cannot convert this court as an adjudicating court and decide about the amount they are entitled to. Insofar as gratuity is concerned, the factum of years of service and the lost on pay is not in dispute. Hence, instead of relegating the employees to go before the appropriate authority, and that they have been divested of the duties under the VRS, and they have divested the body. They have been, that there was a golden handshake scheme by which employees have been disengaged from service. Come on. The employees have to be paid gratuity, and that the employee have approached this court without going before the authorities claiming gratuity, and that there is a delay of 21 years in seeking the relief. The respondent has vehemently contended that the employee having accepted golden handshake scheme and that due to so can you get the ID Act? Industrial Disputes Act 1947.
You need to go to the content. Change now. Since we have
Or the, what is it stated, sir? Mentioned? That due to genuine reasons that the establishment could not be continued after negotiation with the workmen per union has decided to retrenchment of workmen entered into the scheme by which all the employees have been paid the benefits in terms of the voluntary retirement scheme or golden handshake scheme. To stop. It is true that some of the employees have already knocked at the doors of the court and got some benefits. But in the present case on hand, the petitioners have approached this court after 21 years of service, 21 years of their of the cessation of employer-employee relationship, and that it will be very difficult to access to the scheme based on which the benefits have been extended to all the employees, and there is no chance of getting those documents at this stage to ascertain about the genuineness of the claim. However, the employer has not disputed the actual years of service and the last drawn pay of rupees 22,000 per month. The Apex Court in the judgment reported in 1981, so and so has held that the amount payable as gratuity is not a bounty or gratis, and it is a statutory right, and the amount of gratuity receivable by the employee is a property within the meaning of Article 300 capital A of the Constitution of India. Full stop. However, even though the statute provides under section 7(3)(7) within bracket 3 capital A of the Payment of Gratuity Act 1972 to pay interest at 10% per annum in case of non-payment of gratuity. And after the orders of the gratuity by the controlling authority on as affirmed by the appellate authority, the non-payment of gratuity would attract interest at 15% in terms of section 8. However, in terms of section 8(d)(3) or 4, Payment of Gratuity Act, the payment of gratuity cannot be more than the principal amount of gratuity payable. Proviso, sir. 8 proviso. So you incorporate section 3A, 8 on both the notifications, sir. The notification, give you the notification. Since there is an enormous delay, instead of relegating the matter to the controlling authority, and then the authority will have to decide the delay in the first instance, and that there will not be any end to the litigation, in order to give a quietus to the issue on hand and shorten the life of litigation, we are of the view that the payment of gratuity payable to the employee for the actual years of service rendered by taking into account the last drawn pay as rupees 2,000 divided by 16 and multiplied by 15 to be payable to the employee within a period of 1 month from the date of register of the order. We make it very clear that the employees will not be entitled to any interest on the aforesaid amount in terms of section 7(3)(a) or 8 mentioned supra. We also make it very clear that the order passed in this case is applicable only to the 2 employees concerned in this appeal and cannot be treated as a precedent in other case. In case any other employee approaches the court for the similar relief, it is open to the employer, the respondent, to take a defense of laches which will be considered in accordance with law.
My lord, may I pray for 2 months, my lord, because
2 months.
My lord, all right.
All right. Hello.
From supplementary list, item number 1.
How long will it take?
My lord, I'll try to shorten, my lord, 10
minutes.
15 minutes, 15, 20 minutes. I'll try to shorten it.
1:15.
But I'll try. I'll shorten it.
Question of law.
Only on the question of law.
Yes, yes. Only, my lord, with regard to that Meghalaya commercial, I'll just put only one paragraph and I'll go to other points. My lord. My lord, we come to volume 1. Then may I come to relevant para only, ma'am? Para para 48.
Volume 1, para?
Volume 1, page number, my lord, 144.
Page 144.
144. My lord, para 48.
Thank you.
Para 48. Oh, she got it. Para 48 relevant, my lord. And my lord, we come to para 51 and 52. These are relevant. My lord, in this case, the Honorable Division Bench held that the customary toll collection has acquired a force of law. And that becomes a law under Article 30. And that is saved by Article 277 and 372. So that was a statement did not assail before the Supreme Court. Only the petitioner, the Commercial Drug Association, filed an SLP before the Supreme Court. And ultimately, that Supreme Court dismissed that SLP, non-prosecution. And admittedly, state did not file SLP. So my humble submission regarding this context is the order passed by the division benches has attained its finality. State cannot reopen it. Well, that is my reply. Then another one, my lord, the reliance made by the appellant state in the case render in the case of Sidangyuk Dakar versus State of Meghalaya, my lord. I may refer to the relevant paper, volume 3, my lord.
Volume 3.
Volume 3. Volume 3. In that case, writ petition started from page number 1 to 152.
1
page number 1 to 152 is a writ petition.
162.
152. Page number 1 to 152 is the writ petition. And here, my lord, I will point out only a few papers. Public notice, the nature of the disputes in the Sidangyuk case has no connection with the customary tolls collection. Now, may I come to page number 137. 137. 137 was the public notice issued by the district council for appointment of its agent to verify the documents carried by the commercial vehicles carrying minerals. Well, now this is the public notifications. I may not read thoroughly. May I come to the terms and conditions of this notification? I will straight away come to page number 140, the terms and conditions of this contract, where Sitang Yu was appointed as the agent of district council. Page number 140.
148.
Page number, yes, 140. Now, the terms and conditions. The council intends to appoint agent for checking of mineral transport challan or royalty challan carried by all mineral-laden vehicles originating from the council's territory. Number 3, may I come? Lump sum premium to be realized from documents verification fee will be quoted on annual basis for in the words in such. May I come to the next page, 11.1, point 14, page number 141, point 14. Point 14, madam.
Yes.
The operating expense fee allowed to be collected from the transporter challans or mineral transporter after verification royalty challan and related papers shall be rupees 100 and rupees 200. So he was allowed to collect this for verification. And the entire purpose of appointment of Mr. Sitang Yu is to, my lord, to assist the state government to prevent leakage of revenue. No, Mr. Sitang Yu replied to this contract. He was appointed, and he started functioning. He started erecting the stations, verification center, and the district administration started interfering with his collection and verification. And therefore, he challenged before this court. And during that time, my lord, the CAG report says in terms of crores of rupees, leakage of revenue is there, especially with regard to carrying minerals, carrying out from the state of Meghalaya to outside state. Now, the state government, under my lord, the MMDRA, they collect the royalty. And under para 9 of the 6th schedule, district council and the state government share this royalty at the ratio of 25% for the district council and 70% retained by the state government. Now, district council, its khasiyat says that since a huge revenue leakage is there, government is failing in checking the revenue leakage. Therefore, we appoint Mr. Sitang Yu. Sitang Yu will verify the vehicles so that leakage will reduce, so government will collect better revenue, and better revenue will be shared between the district council and the state. So for that purpose, he was appointed. So his collection was interfered by the state government, therefore he filed a writ petition. And therefore, state filed the writ petition. State filed the affidavit. District council also filed the affidavit. And may I take my lord, the affidavit filed by the state government is page number 153. 153 in the same volume. 153. And relevant para would be para 9. I will not read all the relevant statements, but that is the stand of the government, that we are collecting the revenue. Leakage of revenue, it is our duty to check. District council has nothing to do with this. This is the stand of the government. So appointment of Mr. Sitang as agent by district council is not correct. That was the stand. And the deputy commissioner, my lord, affidavit is page number 158. The one who interfered with the running of the verification center. And para 7 is the relevant one.
What page?
Page number 159. Para 7. The deputy commissioner stated that he has quoted para 9 of the 6th schedule. that the sharing is between the state and district council, and in the name of sharing, you cannot appoint your own agent and collect the fees. That is the state. And the district council also filed the affidavit. Madam, may I come to page number 189. And may I come to para 9. Para 9 would be page number 193.
190.
But 193, madam.
93.
193. And relevant para 9. Now, my lord, the stand taken by a council is this, that with regard to amendment made in para 14, 15, and 16 of the writ petition, the answering deponent humbly states that the failure of the state respondents to install effective infrastructure to man and collect the royalty in its jack gates is also known by the pro forma respondent. Being one of the beneficiaries of sharing the royalty, the pro forma respondent expected that the respondent state effectively regulate and control the collection of royalty from the mineral-laden trucks to prevent massive leakage of revenue. The massive leakage of revenue due to complete failure of the state respondent was the impartial findings of the controller and Auditor General of India by such and such placed before the assembly. Hence, the state respondents cannot shy away from discharging its liabilities of controlling leakage of revenue. So the main purpose of the district council is that we appoint Mr. Sitangu to assist the government to net the leakage of revenue. So that authority is questioned by the state government before the learned single bench. And the learned single bench say that, yes, admittedly, there is no law passed by district council for the appointment of an agent to verify the transport challenge, number one. And para 2, do not confer upon the district council to appoint the agent. Therefore, appointment of Mr. Sitangu is incorrect. So that is the finding of the single bench. There was no even a whisper. Sitangu, all the respondents, there is no whisper of, my lord, customary collection of customary tolls. No bleeding at all, and not the issue at all. The only precise issue in that Sitangu is different.
You give the notes.
But
Notes of submission.
I can do that.
How long will it take?
I can do that. This is over. And second point now, third point, well, I'll conclude now. Within 2-3 minutes, I'll conclude. Therefore, my lord, this Sitangu judgment is not applicable in this case. And single bench has rightly appreciated. Third point would be, my lord, AG is heavily relying on the MMDR Act, Mining Minerals Regulation Act. Mining Mineral Regulation Act, my lord, control specific fields. But it has nothing to do with the customary collection of tolls. And with regard to that one, the Honorable Act 2013, with regard to Lordship States Madras, the issue arose before the Supreme Court that whether enforcement of the mining mineral regulation has taken over the ownership of the subsoil rights of the citizen or not. That was the issue in the Supreme Court. Supreme Court clearly held that in the area like Malapal area, that the community will enjoy the subsoil rights. Right? Therefore, MMDR Act operates in a specific confined areas. It doesn't take away the rights of the citizen. So, my lord, I'll just cite that one. I'll not go through the relevant citation. I'll just refer that one for lordship are convenient. That judgment is 2013, volume 9. I've given the list of books. 2013, volume 9, ACC. Page number, my lord, 725. Relevant para would be, my lord, 37, 38. Page 37, 38, 54, and 55. These are relevant there. Relevant.
37.
Madam, 37 and 38, para 37. Madam.
Yes.
37, madam. 31, it reads thus, madam. In view of the PSO number referred to above, we need not unduly trouble ourselves with the metaphysical analysis whether gymnom rights still subsist in lands of Malabal area or whether they are converted into right-to-water lands. Apart from the legal implication of such with respect to Malabal area, this court had already opined that British never claimed proprietary rights over the soil, and Jimnees were recognized to be the absolute owners of the soil. It is obvious from such that the British never claimed any proprietary right in any land in the old Madras province, whether state land, and therefore both Redudi Padadars and Jimnees must also be held to be the proprietors of the subsoil rights minerals until they are deprived of the same by some legal process. Even if we accept the conclusion recorded in the judgment on the appeal that the land in question have been converted to be lands held on right-to settlement, the conclusion recorded by us above with respect to subsoil mineral rights will still hold good for the reason that even in the land held on right-to pada, the British did not assert proprietary rights. Para 54, my lord.
And more specifically with all divorces to 20.
Yes.
So only para 55, Lordship, can you see? Short paragraph.
55.
55. Para 55. Madam, the Mines and Minerals Act is an enactment made by the Parliament to regulate the mining activities in this country. The said act does not in any way purport to declare the proprietary rights of the state in the mineral wealth, nor does it contain any provision divesting any owner of a mine of his proprietary rights, my lord. So I'll not go through the detailed one. Immediately, my lord, in my case also, the British took over, Assam province established, and this presidency of Meghalaya became part of the Assam province, British time. British never taken away these customary rights. It continued, even continued under undivided Assam after independence. State never take away. There was no piece of legislation brought by the state government or the state legislature or the parliament taking away these customary rights. No piece. Now only, my lord, I'll refer to that legislation passed by district council. There are numerous acts passed by the district council empowering collection of these customary tolls. I've given the list of books in the morning, district council compilations. May I start from the volume 2.
Volume 2 is.
In the list of books, it must be there. Yes. Compilation. It is not compilation, it's a compilation by district council.
SJDC Acts and Rules.
You can keep the second volume to my lordships. Yes.
Part 2.
Part 2. Well, in part 2 index, if lordship see, my lord, there are 21 enactments.
21 enactment.
21 enactments passed by district council under 6 schedules, recognizing the customary rights of the CM ships, Siddhar ships, my lord. And in this, my lord, to shorten, there are 12 CM ships whose customary right to collect toll has been recognized under this act. And there are 8 Siddhar ships like me, the respondent here. 8 Siddhar ships, 8 enactments are there, allowing them to collect. And these enactments are passed by district council and receive the assent of the governor under the 6th schedule. Without the assent of the governor, it is not a law, my lord. So I will take mine, out of this, I'll take my own act, my lord. Page number 35 of the part 2.
35.
35, well.
Hmm.
35 is my act, madam. United Khasi Chinde Hills Autonomous District Administration and Election of Sirdar of Maulong Act. I'm Maulong Act, madam, in my case. So this was passed by District Council 1960, and I will come straight to relevant section. My lord, section 24. Lordship may go with me to running page 41. Well, it says, well, the candidate only declare elected shall, now it is his duties, the chief who is elected, his duty, my lord. Carry out all orders, my lord, I'll skip that. Number 2, run the administration of the sitarship in accordance with the customary rules and practices as may be approved by the executive committee and in accordance with such laws, rules or regulations as the case as may be passed from time to time by council. Collect all revenue from Maulang sitarship which are due to the district council and shall deposit the same to district council, district fund, such and such. So I was empowered to run my administration in accordance with customary practices and allowed to collect revenue. I collect revenue like customary tolls and I share to district council. This is one. Another one, I'll come to that specific enactment. If Lordship come to page number 119. Another sitarship act for the another sitarship.
119.
My lord, 119, yes.
190.
119. 119. This is for ANC sitarship. These are the same similar customary institution. Now, this is the main act, and they have framed, district council has framed the rule under the act. And may I come to that rules, page number, my lord, 189. 189. Well, now, this rule shall be called as the Administration of Regency Sitarship Rules 2004. 189. And my lord may come to page number 191. Customary tolls, definition of customary tolls, they have mentioned. 191, 191. At the bottom, my lord, Roman 27, customary tolls. They have mentioned. And when my lord go to page number 193 on the top, Roman 28, toll gate also mentioned. Customary tolls.
Customary?
My lord.
193?
Toll gate, 93, 193, toll gate, lordship mentioned on the top. Toll gates. The toll gates mentioned means any barricade, my lord. Customary tolls. And if my lord come to page number 200, is how they collect. Page number 200, Rule 11, Revenue Administration. Well, Rule 11, well, powers to impose levy and collect customary tolls, royalty, etc. Number 3, madam, as sanctioned by custom usages and convention involved in the sitarship, the office of the sitar shall have the power and rights to impose levy customary tolls. It is mentioned. So they are collecting. This is a separate sitarship. They are not shutting down. State is not shutting down their collection. Even now they are collecting. And another one, my lord, another enactment, I'll come to relevant enactment only. Page number 137. 137, 137. Well, this is no longer sitarship 2000. Enactment is 2000. Governor has given his essay. Without governor assent, it cannot be enforced. And pursuant to this, they have framed the rules, my lord. That would be page number 163. Now, with Lordship permission, I will only take only one act now. That is page number 147. Non-so in same ship, where it is involved in the Meghalaya Commercial Trucker Association case. 147. This is enactment. And they have framed the rules in page number 225. They have framed the rules. This council has framed the rule that is available in page number 225.
225.
225. So under this provision and the rules, no censorship will continue to collect the royalty, the customary tolls. And that was part of the challenge in the Meghalaya Commercial Trucker case before the Honorable High Court. Page number 225. Well, I'll just point out relevant.
You give the gist of notes.
Yes. So this, my humble submission is, my lord, this issue, the issue involved in the Sidangu cases are not at all involved. And it is not the case of the state respondent, the state government, that they are challenging this enactment passed by district councils.
Yes.
Yes, Your Lordship. 4 points. In brief, I have 4 points. First point, what my friend is saying, that the right to collect customary toll has been upheld by.
Any of you argue, we'll see. Any of you around are reserving orders. He's posting the matter on, today we are on 29th February. We're posting the matter on 12th. You give the return notes.
Yes, sir.
Thereafter we'll reserve.
Sure. Yes. So I'll keep an.
Tuesday. I cannot